An executive directive can void a contract. It cannot rewrite a criminal statute. That single distinction sits at the center of the reported White House directive, ordering federal agencies and elements of the intelligence community to waive or cancel non-disclosure agreements binding former employees and contractors with knowledge of unidentified anomalous phenomena. On its face, it's the most aggressive executive gesture toward UAP transparency in the modern era. Read closely, it may change far less than the headlines suggest. Because the thing that silenced David Grusch in a congressional hearing room in July 2023 was never primarily an NDA. It was classification, and classification is a separate legal machine entirely. Let's be precise about what is and isn't confirmed. According to reporting on the directive, agency heads are instructed to identify former personnel bound by secrecy agreements touching UAP-related programs and to release them from those obligations so they can come forward. The framing echoes language disclosure advocates have pushed since 2023 that a generation of engineers, program managers, and contractor staff are sitting on knowledge they legally cannot voice. What the public text does not appear to include: a declassification order under Executive Order 13526, a blanket grant of immunity, or a mechanism compelling private defense contractors to release employees from proprietary agreements they signed as a condition of employment. Those omissions are not technicalities. They are the whole ball game. There isn't one NDA. There are at least 4. Standard Form 312 is the baseline classified information non-disclosure agreement signed by every clearance holder. Form 444C covers sensitive compartmented information. Special access programs layer on separate indoctrination and debriefing agreements, often program-specific and read-in by name. Then there's the 4th category, private contracts between an individual and Lockheed, Raytheon, Battelle, or any subcontractor beneath them, including trade secret and proprietary information clauses. The government can waive the first 3 because the government is the counterparty. It cannot simply void the 4th. It can direct contracting officers to seek waivers, and it can condition future business on cooperation. That's leverage, not law. Which agencies actually execute and how narrowly they read their own obligations will determine everything. Here is the part that rarely makes it into coverage. An NDA is a contract. Breaching it exposes you to civil liability, loss of clearance, forfeiture of pension in some cases. Waive it, and that exposure disappears. But disclosing properly classified national defense information remains prosecutable under the Espionage Act, 18 U.S.C. paragraph 793, regardless of what any agency signed away. Section 798 covers communications intelligence, and restricted data under the Atomic Energy Act, 42 U.S.C. paragraph 2274 is born classified, sitting outside the ordinary declassification authority of Executive Order 13526 altogether. If recovered materials programs were ever compartmented under Department of Energy authorities, as multiple claimants have alleged, an NDA waiver touches none of it. The sharper criticism is that most of this authority has been on the books since December 23, 2022. Section 1673 of the FY 2023 National Defense Authorization Act, Public Law 117-263, established a secure mechanism for current and former government employees and contractors to report UAP-related activity, and provided that non-disclosure obligations may not be invoked to block those authorized disclosures. Layered on top, 5 U.S.C. paragraph 7211, protecting the right to furnish information to Congress. 50 U.S.C. paragraph 3234, the Intelligence Community Whistleblower Framework. 10 U.S.C. paragraph 2409 for contractor employees. AARO opened its secure reporting portal on October 31, 2023. As of public reporting, the volume of substantive first-hand disclosures has remained modest. The bottleneck, critics argue, was never permission. It was fear, and it was classification. David Grusch is the controlling case study. A former National Reconnaissance Office and National Geospatial Intelligence Agency officer, he filed an Intelligence Community Inspector General complaint in May 2022. The ICIG found his allegations urgent and credible. He went public through the debrief on June 5, 2023, and testified under oath before the House Oversight Subcommittee on National Security on July 26, 2023. He was by then a legally protected whistleblower with a prepared statement cleared through the Defense Office of Pre-Publication and Security Review. And still, repeatedly, on camera, "I can't discuss that in a public setting." Protections got him into the room. Classification kept the specifics out of the transcript. An NDA waiver, by itself, changes nothing about that arithmetic. Now the structural question almost no one is asking. Waived to say what and to whom? Disclosing into AARO or into the body reported under the acronym PURSUE, whose statutory footing and reporting chain remain unclear in public sources, is not public disclosure. It is intra-executive disclosure. Testimony given to an executive office can itself be classified on receipt. It can be compartmented. It can be summarized for Congress by the same institutions the witness is accusing. Public testimony, or sworn closed-door testimony to a committee with subpoena and referral power, is a categorically different act. It creates a record outside the chain of command. A waiver that routes witnesses inward is a containment strategy. A waiver that routes them to Congress is disclosure, which brings us to legislation and to why an executive order is structurally weaker. The UAP Disclosure Act, introduced by Senators Schumer and Rounds in July 2023, was modeled on the President John F. Kennedy Assassination Records Collection Act of 1992. Its core was a 9-member review board, presidentially appointed, Senate confirmed, armed with subpoena power, operating under a presumption of immediate disclosure with eminent domain over recovered materials. Conference negotiations in December 2023 stripped the board and the eminent domain provisions. What survived in Public Law 11831 was largely a records collection at the National Archives. Representative Eric Burlison of Missouri has pushed the full version in the House, alongside task force members including Anna Paulina Luna and Tim Burchett. The difference is durability. A directive can be rescinded by the next signature. So how do we judge this? 4 measurable things. Whether individual, written waivers actually issue, naming programs, not gesturing at categories. Whether pre-publication review is reformed because DOPSR is where cleared testimony goes to die. Whether any accompanying declassification authority is invoked under Executive Order 135-26, and whether a single new witness testifies publicly under oath with specifics. If those happen, this is genuinely historic. If none do, it functions as permission to speak inside a room the public cannot enter. The Grusch hearing already demonstrated that legal protection without declassification produces a witness who cannot answer the question. Removing the NDA is the easy half. The hard half is the classification stamp, and nothing announced so far touches it.